So today's second panel is titled, When Should Courts Step In and How? It's moderated by Leah O'Connor. I'll hand this over to her in just a moment, but I do want to introduce my friend. Lee served from 2001 to 2007 as Assistant Attorney General for the Tax Division of the Justice Department. More recently, in the aftermath of the last presidential election, she served on the transition and then on the landing team for the Treasury Department. She's in private practice now. She also chairs the Federal Society's Administrative Law Section Executive Committee. And so it's my great pleasure to welcome Lee and turn things over to her. Thank you.
Thank you, Adam, and thank you all for being here today. I think you're going to enjoy our panel. The next panel is entitled, When Should the Court Step In and How? We're fortunate to have with us for this morning's discussion 4 people who are respected as experts in administrative law. Each of them has accomplishments and publications too numerous to list. A short form of their biographies is in your program. So to maximize the time available, my introductions will be brief. I will call your attention to, however, to the fact that I noticed that some of you are looking at the page of bios. I want you to appreciate the fact that the panelists provide these bios to the conference organizers, and that you should in no way equate a short bio with a lack of achievements. So, as Adam said, you'll notice there's one bio in there that's really short. I interpret that as modesty. But you can go to the web pages of any of these panelists and see a more complete listing of their publications, and you'll be very interested to do that. So I'll introduce the topic and the panelists and moderate the discussion. Each panelist will make opening comments of about 10 minutes, give or take a couple, after which they'll respond to each other, and then we'll open to the floor for your questions. Professor Kristen Hickman will speak first. She co-wrote one of the papers commissioned for this conference, Pursuing Pragmatic Finality in Agency Action. Professor Hickman is the Distinguished McKnight University Professor, the Harlan Albert Rogers Professor in Law, and Associate Director of the Corporate Institute at the University of Minnesota Law School, where she has been teaching since 2004. She has also taught at Harvard Law School and Northwest University Law School. Professor Hickman's scholarship focuses on the areas of taxation and administrative law more generally. With Dick Pierce, she is the co-author of the Administrative Law Treatise, as well as a textbook on federal administrative law. She studied at Trinity University in San Antonio, Texas, earning a Bachelor of Science degree in Business Administration with a concentration in accounting and a second major in history. After practicing for several years as a certified public accountant, she earned her JD degree magna cum laude from the Northwestern University School of Law, and then clerked on the United States Court of Appeals for the D.C. Circuit for the Honorable David Sentel. Before joining academia, Professor Hickman was an associate with the Chicago office of Skadden Arps, concentrating on corporate and international tax transactions and matters. Professor Nicholas Perillo will speak second. He wrote another of the papers commissioned for this conference, Negotiating Governmental Compliance with Court Orders. Professor Perillo teaches administrative law at Yale Law School. He has also taught courses on government bureaucracy, remedies, and legal history. He earned his undergraduate degree in history and literature, summa cum laude, from Harvard. His law degree from Yale, winning a Best Paper Award each of his 3 years there, and finally a PhD in American Studies, also from Yale. Among other activities between law school and his PhD, Professor Perillo clerked on the United States Court of Appeals for the D.C. Circuit for the Honorable Stephen Williams. Professor Perillo is a public member of the Administrative Conference of the United States and has been serving as a consultant to the conference to conduct a study of federal agencies' use of guidance documents. His most recently completed project is an article titled The End Game of Administrative Law, Governmental Disobedience and the Judicial Contempt Power. It's scheduled to be published next month in the Harvard Law Review. Speaking third will be the panel's token practitioner, Andrew Grossman. He will comment on the presentations of Professors Hickman and Perillo and will introduce some new concepts, the availability of equitable remedies against government agencies. Mr. Grossman is a partner in the Washington, D.C. office of Baker and Hostetler, where he practices appellate litigation. He is also an adjunct scholar at the Cato Institute. He has written widely on law and finance, bankruptcy law, administrative law, and the constitutional separation of powers. He is a frequent advisor to members of Congress on complex legal and policy matters, particularly concerning constitutional limitations on federal power. Mr. Grossman is a graduate of Dartmouth College, University of Pennsylvania Fells Institute of Government, and the George Mason University School of Law. He clerked for Judge Edith Jones, excuse me, of the United States Court of Appeals for the Fifth Circuit. Finally, in addition to I'm sorry, I have to have a Rubio moment. Finally, in addition to commenting on the presentations of the first three speakers, Professor William Busby will offer some comments on recently initiated deregulatory actions, the likely logic behind them, and the possible vulnerabilities of these strategies. Professor Busby is a professor of law at Georgetown University Law Center, teaching, lecturing, and writing in the areas of administrative, constitutional, environmental, and land use law, federalism, legislation, and regulation. He joined Georgetown's faculty in 2014 from Emory University School of Law, where he headed that school's environmental law program and co-headed its Center on Federalism and Intersystemic Governance. He has been a visiting professor at Columbia, Cornell, and other prestigious law schools. While at Emory, he was honored for excellence in teaching. Professor Busby earned his bachelor's degree from Amherst College, magna cum laude, and his law degree from Columbia. He began his legal career clerking on the Second Circuit for Judge Jose Cabranes, and before joining academia, was an attorney fellow at the Natural Resources Defense Council, where he conducted and he also conducted environmental land use and litigation work for the New York City law firm Patterson, Belknap, Webb, and Tyler. That concludes the introductions, but before I hand off to the first speaker, I'll mention one recent development and one anecdote from my own experience that are relevant to our topic. When should the court step in and how? First, the recent development. Last month, Attorney General Jeff Sessions issued a memorandum to all components of the United States Department of Justice declaring that, effective immediately, department components may not issue guidance documents that purport to create rights or obligations binding on persons or entities outside the executive branch. The memorandum provides 5 principles which any future guidance documents must comply with, and directs the Associate Attorney General to identify existing guidance documents that should be repealed, replaced, or modified in light of these principles. The Attorney General's announcement that the Justice Department will no longer promulgate guidance documents that do not comply with the Administrative Procedure Act or other relevant requirements strongly suggests that neither will it defend the non-compliance documents of other agencies. So it is possible we will soon see that the sorts of challenges reaching the courts are changing, or more specifically, that one sort of challenge will evaporate completely. And the anecdote is this. Based on an IRS guidance document which had stood for 50 years and been cited as authority by the Supreme Court, a corporation filed a claim for refund with the Internal Revenue Service of its overpaid taxes. The IRS denied the claim, and then it revoked the guidance document on which the claim had been based and commenced a project to issue a new guidance document, reaching the opposite conclusion. By the time the refund suit got to court, the IRS had issued the new guidance document supporting its denial of the refund claim. The government ended up settling the case, but it seemed to me that the IRS's actions in this case undermined the arguments it makes to courts that its guidance documents deserve any respect at all. Now to the panel. Professor Hickman.
Sorry, we're so electronic these days. I've got my timer to keep me on time, and I've got my notes on my tablet and everything like that, so I feel like I'm sort of a gadget queen up here. Is this my clicker? Okay. So I want to start by thanking Adam and Leah for putting together a great program. I love what they're doing with the center, and in absentia, Naomi Rao as well. I also want to acknowledge that even though I'm up here speaking today, my co-author Mark Thompson is in the audience. We decided I would do this speaking, but at the same time, this really is a project that is truly co-authored with us working very closely together. As the title suggests, Mark and I are writing an article about finality doctrine, but I want to take just a minute to put this article into a broader context because, at least in my own head, it's really part of a larger project. So when I was in law school, and then when I clerked for Judge David Santel at the D.C. Circuit, I learned about justiciability doctrine as an exercise of judicial restraint. And in that spirit, it's my informal impression, although my own research is starting to bear this out, that at least some judges in the 1980s and the 1990s responded to 1970s judicial activism in the regulatory sphere by tightening up justiciability doctrine and limiting the availability of judicial review. But times change. Agencies change their behavior in response to judicial doctrine. Maybe sometimes that's a subconscious change, but they do change. And I fear that perhaps the pendulum has swung too far, leading judges precariously close to abdicating their role as Congress envisioned it when it enacted the Administrative Procedure Act of ensuring that agencies stay within the boundaries of their statutory authority. Back in 1967, the Supreme Court in Abbott Labs spoke eloquently about the Administrative Procedure Act advancing a presumption in favor of judicial review of administrative action in order to protect regulated parties from the Hobson's choice of complying with requirements of agency action and incurring the costs of changing business practices or following their present course and risking civil or even criminal penalties. Judicial review serves an absolutely critical function in preserving public perceptions regarding the legitimacy of agency action. We have all of this talk these days that the courts ought to overturn Chevron or our deference so as to better police agency overreach, but overturning Chevron or our deference only gets you so far if you can't get into court in the first place. So, with that background in mind, let's take a look at finality doctrine. The contemporary standard for evaluating finality comes from Bennett versus Speer and asks two questions, although the second question I think arguably is something of a two-parter. So first, the action must mark the consummation of the agency's decision-making process. It must not be of a merely tentative or interlocutory nature. And second, the action must be one by which rights or obligations have been determined or from which legal consequences will flow. That's sort of the two-part aspect of that second prong. Now, other than telling us that the Department of Fish and Wildlife biological opinion at issue was in fact final agency action, the court in Bennett versus Speer really didn't tell us very much about what it meant by any of this standard. There are two things I think we can say about the standard, though. The first is that the court didn't repudiate its prior finality jurisprudence. And in fact, in the Hawks decision in 2016, the court described the Bennett Standard as a distillation of its then existing finality jurisprudence. The second thing I think we can say about the Bennett Standard is that it's underexplained. And when viewed in isolation, it's susceptible of more than one interpretation. And the result, perhaps not too surprisingly, is a fair amount of inconsistency among the circuit court decisions applying the Bennett Standard. And here I don't just mean irreconcilable outcomes, but that the circuit courts have offered different glosses, if you will, on exactly what it is that the Bennett Standard means and what it requires. So, due to time constraints, I'm going to refrain from elaborating in great detail here, except to say that there are a bunch of sites up on the slide, and the court cases are really, really very interesting in their different approaches. The Third Circuit has a 5-factor gloss on Bennett versus Speer that it pulls from its own jurisprudence. The D.C. Circuit has its own different 3-factor gloss. But the judges on that court also seem to disagree about whether those 3 factors apply to all finality assessments or just a subset of actions that the court has labeled comply or else. Meanwhile, there are a few circuit court opinions that try more or less to equate particularly the second Bennett prong with other doctrines that rely on whether agency action carries the force and effect of law. For example, in distinguishing between legislative rules and non-legislative ones, or determining whether a particular agency action is eligible for Chevron deference. Now, as the paper observes, a shared characteristic of these different circuit court approaches is that they tend to frame the Bennett Standard and the finality inquiry more legalistically than pragmatically. All in all, you can think of finality cases as falling along a continuum, bounded by pragmatism on one end and legalism on the other. And even as the Supreme Court, in cases like Sackett and Hawks, seem to be signaling in favor of interpreting the Bennett Standard along pragmatic lines, and that's consistent with most of the court's earlier finality cases as well. A number of the circuit court opinions seem to be, through their different approaches, nudging finality analysis toward the more legalistic end of the scale. And that greater legalism means less judicial review. But the variability in how the courts talk about finality doctrine also yields just a tremendous amount of uncertainty among regulated parties as they endeavor to evaluate the likelihood of successfully challenging agency actions in court. Now, maybe this wouldn't matter too terribly much if the agency actions looked like they did at the time that Congress enacted the APA, or even if agency action looked like it did in 1997 when the court announced the Bennett Standard. But agency action really doesn't look today quite like it did 20 years ago or 60 years ago. We have one circuit split over finality doctrine that has lasted a long time, and that concerns Department of Labor Wage and Hour Division opinion letters interpreting the Fair Labor Standards Act. But most of the examples that Mark and I talk about or will talk about, we're still developing this section in the paper, reflect what we see as a shift in how agencies use different formats to communicate interpretations of law. These aren't examples where we have a large number of cases. Often, instead, they involve anecdotal evidence in which one or the other of us was made aware of a situation in which regulated parties thought to challenge agency action, but decided not to precisely because they were concerned that the court would decide that the agency action in question was not final. There was just too much uncertainty to be worth bringing the litigation in the first instance rather than simply complying. These are situations in which, for example, an agency issued an interpretive ruling at time A, saying that a particular course of behavior was permissible, but then issued another interpretive ruling at time B, changing its mind and saying that the same course of behavior is now prohibited. In Mortgage Bankers Association versus Perez from a couple of terms ago, the Supreme Court said that a court can't require an agency to use notice and comment rulemaking procedures to replace an interpretive rule, and that's fine. But the agency changing its mind might lead to invalidation of the agency action under either Skidmore or State Farm, assuming we can get to court in the first place. Or consider another one of my favorites, IRS notices, the issuance of which triggers the statutory authority to backdate future IRS regulations interpreting the tax laws and change the tax implications of particular transactions retroactively. In other words, the significant uncertainty created by the high level of variation in finality jurisprudence leads litigants to make the very choice that Abbott Labs decried, to comply with agency actions they see as illegitimate to avoid potential civil or criminal penalties, rather than pursue litigation out of concern that a pre-enforcement legal challenge would be in vain because the court would consider the agency action in question to be non-final. So where do we go from here? I hope the punchline isn't too anticlimactic. Mark and I don't suggest that the courts repudiate the two-part Bennett test. We aren't looking to revolutionize finality doctrine, and we're wary of going too far and chilling the speech of agencies, which itself would undermine the APA's transparency objective. Instead, Mark and I have much more modest goals, which are simply to point out the doctrinal trends and inconsistencies in the circuit court level and to contextualize, I didn't know it was going to go off like that. How do I make it? There we go. And to contextualize the Bennett Standard by discussing its theoretical premises and by situating the Bennett Standard within the court's broader finality jurisprudence. And through that contextualization, we seek to caution courts against abdicating their role of checking agency excesses and just to nudge the courts a little bit more to the pragmatic end of the continuum. So the case law only talks a little bit about the justifications, oops, I went too far, about the justifications for the finality requirement, and those justifications tend to be pretty generic, resembling those for other timing doctrines like ripeness and common law exhaustion. Courts recognize that agencies have their own role to play in our system, and prematurely intervening in agency decision-making usurps that role and wastes judicial resources. But unlike ripeness and common law exhaustion, finality is a statutory requirement. It comes to us from the APA or from organic statutes that we interpret consistently with the APA, and as such, we ought to balance the goals of the finality requirement with other APA goals like transparency and accountability and reliance on the courts as a check against abuses of agency power. So thinking about the Bennett Standard in these terms takes us back to cases like Abbott Labs that emphasize the practical day-to-day consequences of agency action. We can then look at the Bennett Standard's elements and construe each one to cast a somewhat wider net than some of the narrower and more legalistic interpretations would. So, for example, when thinking about the Bennett Standard's consummation prong, even if a particular agency action doesn't represent the culmination of everything that the agency intends to do with respect to a particular topic, agency actions often fall into a series of interrelated actions toward a particular end, and there may be an intermediate step in the chain that reflects the consummation of some aspect of the agency's decision-making and leads to particular consequences for later steps in the chain. And maybe we ought to interpret consummation of the decision-making process in terms of those smaller bites rather than thinking all the way to the end of the chain. Or when thinking about the legal consequences aspect of the Bennett Standard, the court's broader jurisprudence suggests that we ought to think not only of the legal consequences for regulated parties, but also the legal consequences for the agency itself, and what the implications of agency action are for the agency as well as regulated parties. In sum, Mark and I don't think that finality doctrine needs to change all that substantially. We're simply concerned that courts are starting to lose the forest for the trees, and so we're hoping to reorient the court's focus back to the forest. And with that, I'll wrap it up.
Thanks very much to Adam and Leah for organizing the conference. Kristen discussed whether a court will allow a challenger to get to the merits in the first place, and I'll be talking about the question that arises at the opposite end of the suit. If you sue an agency and get to the merits and win on the merits, what will the court actually do for you in terms of a remedy? So usually what the court does is issue a judgment either setting aside action that the agency took or compelling action that the agency withheld. And one may assume that after that's handed down, the agency just obeys and it's over. But in fact, federal agencies' compliance with court orders can be complicated and fraught, particularly with orders that seek to compel the agency to affirmatively do something. The issue is this. The thing the court is ordering the agency to do may be costly or complex. For example, drawing up a regulation for a pollutant, designating critical habitat for a protected species, reforming the processing of claims for some benefit. If the ordered action is costly or complex, then complying with the order may put a strain on the agency's limited personnel and funding and may slow down the agency in carrying out all of its other tasks that are required by law. And also, rushing that kind of action may cause the agency to act before it's gotten the necessary technical information on which to base the action, which could result in the action being clumsy or counterproductive. And a judge has to consider all these constraints on the agency when the judge is deciding how hard to press the agency. For example, whether to set a deadline for the agency to act, how short a deadline to set, and whether to extend the deadline if and when the agency comes back to court saying, "Judge, please, you got to give us more time." The way that judges negotiate the terms of compliance with agencies and challengers is quite significant to the efficacy of judicial review of agency action. But there isn't much academic research on these compliance negotiations, and I suspect that's because there isn't much on compliance in the way of doctrine and appellate case law. To learn about it, you need to delve into unpublished orders, motions, status reports, and the like, often at the district court level. My research team and I have conducted several database searches of unpublished opinions, docket sheets, and filings with the immediate aim of addressing one key question about these compliance negotiations, namely, what is the end game? Okay, that is, if the judge concludes that the agency, in asking for more latitude, is being unreasonable or even politically recalcitrant, what, if anything, can the judge do to make the agency swallow its reservations and just do what's been ordered? In litigation against private defendants, there would be an obvious answer. The judge can threaten the defendant with a finding of contempt, which can come with sanctions of fine or imprisonment. My team and I located over 1,000 civil actions over the last few decades in which a court was asked to consider a finding of contempt against a federal government defendant, including several dozen in which the judge actually did issue such a finding. Drawing upon these suits, I previously wrote an article on the use of the contempt power against federal agencies, and basically there's legal uncertainty about whether contempt sanctions, things like fining the agency or imprisoning the responsible official, whether those kinds of sanctions are available at all against federal defendants. And courts are almost completely unwilling to use such sanctions as a prudential matter. But mere findings of contempt, even when there's no sanction attached, have a shaming effect on federal defendants, and that shaming power makes contempt, in a lot of contexts, a pretty effective stick. So here in my paper for this symposium, I've gone back over this assembly of suits where contempt comes up, and I've focused on the vast majority of cases in which the judge, the agency, and the challenger negotiate over compliance in the shadow of the contempt power, but without things escalating to the point of a contempt finding. The symposium paper lays out some ideas on how these compliance negotiations work in the day-to-day. These ideas are meant to be exploratory. A more definitive treatment would require looking at a larger range of suits and also doing interviews to get at the unrecorded aspects of these negotiations. But with those caveats in mind, at this stage of the research, I'd say the theme that stands out most from the sources is the informational problem that the judge faces. Okay, to make a judgment about whether a non-compliant agency should be pressed harder or instead given some slack, we might want to know what progress the agency has made, what resources it's allocated toward compliance, whether it's using those resources efficiently, what other priorities are competing for those resources, whether additional effort would actually increase the soundness of the agency's ordered action, and whether the agency has ulterior political motives for not complying. Truly answering these kinds of questions would require some major fact-finding. But traditionally, the fact-finding in suits against federal agencies is quite limited. The usual approach is not to allow discovery. Instead, the court decides the suit based on an administrative record assembled within the agency and certified to the court. But when it comes to compliance problems, which usually arise in challenges to an agency's failure to act, there often is no administrative record, or the record is inadequate. Instead, fact-gathering has to be done in the first instance in court. But commonly, there still isn't any discovery consistent with the general pattern of administrative law. Instead, there's more likely to be declarations from agency officials about their progress and efforts, status reports from the agency, and the like, none of which are subject to full-blown adversary fact-finding processes in the court itself. Usually, the detail and documentation of these filings is granular enough to make a facially plausible claim that the agency is making a reasonable effort at compliance, while still asking the court to take a lot on faith. When judges face this kind of situation, what do? Well, judges will often tell the agency it has to make some kind of steady progress. For example, a certain number of claims processed per month, a certain number of months for each stage of a rulemaking, etc. If the agency initially follows this schedule but then later falls behind, that prompts the judge to make the agency explain, why have you fallen behind? But it's often unclear how the judge chooses in the first place what rate of progress to tell the agency to achieve. Or rather, sometimes it is clear, but what's clear is that the judge's method for deciding the rate of progress is pretty crude. For example, judges will base the required rate of progress on the agency's own proposal as to what seems reasonable, or splitting the difference between the agency's proposal and the challenger's proposal, or the agency's usual pace of work in the past, assuming that slowness is not the very issue in the litigation, or on rates that were required of the same agency in past lawsuits, but sometimes with little attention to whether those suits involved comparable agency proceedings. While these methods may be crude, you could argue that making a more sophisticated judgment just isn't feasible. It would require intrusive discovery to determine the agency's internal managerial capacities, and it would require the judge to put on a hat almost as a management consultant, telling the agency how to efficiently use its resources and order its priorities. Occasionally, you see a court obtaining the views of outside experts about an agency's capacity to do a certain kind of work at a certain speed. For example, a declaration from a former official at the agency, who used to run this office and says, I think they can do it this fast, or something like that. But that kind of evidence is pretty rarely invoked. More commonly, the court is asked to take a lot of what the agency says on trust. And indeed, judges generally start from an assumption that they should trust the agency to make judgments about what is feasible. Notably, an agency can lose the judge's trust if it deviates from whatever schedule or expectations the judge has set up with too little advance warning or with too little explanation. This can result in the court attributing bad faith to the agency and then threatening more intrusive requirements or discovery or a contempt finding. That said, agencies may be able to recover from a loss of trust if they make their operations a lot more transparent to the judge going forward. I should add, finally, that courts will sometimes adopt measures that are officially meant to gather information about the non-compliant agency's management, but are unofficially meant simply to get the agency management's attention and force it to give a higher priority to the action that's been ordered by the court. For example, a judge may order a top official at an agency to testify at a hearing or allow such an official to be deposed. This kind of thing threatens the top official with the possibility of embarrassment and the certainty of some onerous prep time. To be sure, the government is often successful in getting appellate courts to block these measures on the ground that if all courts use these measures against all agencies, high officials would have their whole calendars eaten up by litigation. Nonetheless, these measures aren't always blocked by the higher courts, and the mere threat of them has sometimes induced high officials to devote more agency time and personnel to whatever the judge wants in the hope of heading off the hearing or the deposition or whatever it is. As they say, the prospect of having to explain oneself concentrates the mind wonderfully.
Hi. Unfortunately, I don't have a slide deck today, and in fact, I don't even have a paper, but I'm offering some remarks that I hope, given time and some effort, could perhaps result in a publication. But they are, of course, at a very early and preliminary stage. If I had to give this a title, I would call it New Adventures in Equity. As attorneys, of course, we're trained in the law. We live in an age of statutes. So I think too often we fail to consider the availability of equity and the demands and requirements of equity. Oftentimes we spend a lot of time thinking about, has the government violated the law? Well, what do? You get an injunction. Well, okay, that isn't necessarily so straightforward. The equitable considerations that are required to get injunctive relief are things that, in cases from time to time, lead to very unexpected and sometimes frustrating results. Now, it isn't exactly accurate to say that the enforcement of the equities against government agencies is entirely doctrinally underdeveloped. Because after all, equity was really the only game in town until the rise of statutory remedies in the mid-20th century or so. So there actually is a very rich law of equity and equitable remedies against the government, but in many cases it's been forgotten or displaced. In some instances, in fact, it's been shoved aside. I think there are areas people can point to where the availability of review under the APA has effectively curtailed the availability of so-called non-statutory review that had previously been available for certain types of government conduct, like certain types of non-final government actions that can cause injury in some instances, that effectively can't be challenged under the APA. But nonetheless, despite the rise of statutory remedies and indeed their dominance at this point, the equities remain relevant to when and how the courts step into police agency conduct. A simple question: can you seek money from the government in an APA suit? If you ask your attorney that, the answer you're likely to get is no money damages. That's what the sovereign immunity waiver says. But actually, the answer is yes, at least in certain circumstances. You can't get money damages. They're excluded from the sovereign immunity waiver. But equitable actions for specific relief are, as the Supreme Court recognized in Bowen and in other cases, available in equity. That case in particular sought reimbursement for funds expended by a state that it contended ought to have been funded by Medicaid. So again, this was a question of effectively specific performance. The government is enforcing the statute, and therefore it has to, under this particular view of the statute, reimburse certain expenses that the state incurred. So what is specific relief? Per Judge Bork, it's an attempt to give the plaintiff the very thing to which he was entitled. Now, again, that's to be distinguished from money damages, which are outside of the sovereign immunity waiver, and which, as Judge Bork explained, refers to a sum of money used as compensatory relief. So you have this distinction when you're talking about monetary equitable relief, at least, between the very thing to which you're entitled versus some type of compensatory or substitute relief. Now, the big one, of course, within that rubric is funds to which one might be entitled under a statute. So in Bowen, obviously, the Medicaid funding. That's specific relief, not specific performance. And this is the kind of thing that arises regularly under statutory schemes. Often these are brought as pre-enforcement challenges, so the flows of money may not have occurred yet at all. But sometimes they all are brought where there is a remedial component to the relief that is sought, as well as prospective relief as well. In other words, people want money for what they have done or what they're entitled to for past conduct. Now, where does that leave? Now, what the courts have called this in different circumstances, in some cases they call it specific relief, in some cases they call it specific performance, in other cases they call it simply an injunction. The government is enjoined from not following whatever the court decides the law requires it to do. Bowen, in fact, calls it all three. It was a very long opinion, and Justice Stevens was not so precise with his language as Judge Bork was. But as he could do quite uniquely in his later career, Chief Justice Rehnquist really did proceed to clean up the language with a very minimum of fuss, as well as, unfortunately, somewhat of a minimum of reasoning. He addressed what naturally followed from Bowen was the availability of equitable compensation. If you can have some type of equitable monetary remedies, well, why not equitable compensation? A long string of older cases, in fact, some as late as the 1960s, recognized it. And the Chief Justice initially simply said that it was outside of the court's jurisdiction. Why? How? Who knows? But ultimately, the court was required to put this on at least somewhat of a firmer jurisprudential basis in 1999 in a case called Department of the Army versus Blue Fox. And that's when it adopted a very narrow and restricted view of specific relief. So it's not all kinds of monetary equitable relief. It has to be some very specific thing. And the court has been very clear about that. But okay, what are those specific things? Back pay? Well, some circuits have dabbled with that idea, but not in the DC Circuit. In the DC Circuit, the view is that back pay constitutes compensation. It's damages. It's not something specific. Where did they get that from? Dobbs. I think a general rule regarding equitable remedies, something that a practitioner would be well advised to follow, is that the courts are generally flying blind with the contours of these remedies, and Dobbs effectively is their primary navigational aid. What about money or property held by the government? Through the 1920s or so, decisions from time to time recognized what might be called equitable liens or trusts. Again, this could be characterized as another instance of specific relief. Some decisions, even through to the current day, do recognize what amount to equitable liens on specific property that's being held by the government. Specific relief can also include actions for refund. This can reach, for example, fees and assessments. This has happened in cases involving assessments levied by the FDIC on banks, checkoff assessments on almond handlers, funds paid to the U.S. Nuclear Regulatory Commission, as well as most recently, in a case in which I was involved, checkoff assessments paid to the Department of Agriculture for softwood lumber imports. The key point, of course, when you're seeking a refund, is that the party on the other side of the V should probably not be the Commissioner of the Internal Revenue Service. If he is, you may have some problems. Now, fees, of course, are ubiquitous across the government, and the availability of an equitable refund remedy can actually provide a lot of leverage, and I think this is something that's been a little bit underdeveloped. The remedy can be not only in terms of the money, but in terms of obtaining judicial review of the agency's conduct. In other words, you might, in some instances, go forward with an undue delay action, and the question before the court in that instance is whether the agency unduly delayed. But if you're seeking a refund, potentially you can be challenging the good faith of the agency's conduct. And potentially this type of suit can provide a vehicle to explore an agency's possible bad faith or their faulty or challenged administration of a particular statutory scheme. And this can be an important way to obtain judicial rulings on these types of issues, particularly now that the Supreme Court has closed the door on Bivens actions that might cause courts to similarly address these in, say, a First Amendment retaliation context. I think another vehicle for the same concept is the equitable doctrine of unclean hands. As one court put it, unclean hands is a self-imposed ordinance that closes the doors of a court of equity to one tainted with the inequitableness or bad faith relative to the matter in which he seeks relief. Effectively, unclean hands can be a defense to nearly any request for inequitable relief, including injunctions that the government may seek. Now, there is some dispute, but most courts have held that the unclean hands doctrine does bar equitable relief when it's sought by the government, at least in certain circumstances. And so from time to time, in very hard-fought cases where there really is a fundamental disagreement between a particular citizen or a company, as well as a recalcitrant government agency, the doctrine of unclean hands rears its head. And potentially, it is a very powerful record. There may be a basis to effectively abrogate the agency's equitable authority to take actions against a particular person or a particular company. And it provides a vehicle, again, to put that government agency's conduct under the microscope in court. It's an equitable concept, and so potentially everything is relevant. Again, in the wake of the Supreme Court's decision in Ziegler, where it's difficult to obtain review of what may be bad faith or abusive government conduct, it can be important to obtain judicial review and relief on those types of issues. It may not get you any money, but it can certainly get you a judgment that government officials acted in bad faith, and that can be an important and sometimes very valuable thing, especially when one has ongoing business interests. These same general thoughts, albeit to a somewhat lesser extent, of course, apply under ordinary equitable balancing. And I think we're seeing a lot of this now, to a certain extent, in the so-called legal resistance to the Trump administration's actions. I don't think any of them, at least that I've seen so far, have had the opportunity to roll out the defense of unclean hands But I think it's only a matter of time before that happens and before certain groups do attempt to use that as a weapon against the government to obtain intensive fact discovery on its actions and on its internal considerations in a way that might be unavailable in other types of legal actions. So finally, a few thoughts on injunctions, because of course it is by far the most prevalent form of equitable relief against the government. When should the courts step in? Well, if the first year of the Trump administration has taught us anything, it's that the federal courts are eager to entertain claims in equity against the government, and the court's perceptions of the equities can often do a lot of the heavy lifting, perhaps in some instances more so than the law itself. Of course, the governing principles here are somewhat in flux. What's the proper remedy for unlawful agency action under the APA? Well, everybody knows it's to, quote, set aside the offending action. But at the same time, the Supreme Court has repeatedly recognized courts' equitable authority and sometimes obligation to tailor remedies to the circumstances at hand. So where does that leave, for example, nationwide injunctions? Arguably, they are authorized by the APA. You set aside the offending action. But they may not be equitable. In fact, as Sam Bray, I think, has very persuasively written, the remedy was unknown to equity and really only came into its own in the 1980s and 1990s. And why stop at standard issue injunctions against particular government agencies? So much of what we seek or could seek is properly described, in fact, as specific performance. And can a district court order, as a matter of specific performance, an agency to do just about anything under the sun? Well, it's happened. In that same case against the Department of Interior that was discussed earlier today, Judge Lamberth ordered the Department of the Interior off the internet and effectively shut down all of its operations. Can a judge order an agency to set aside funds for a potential refund, to segregate them? Of course, they do that all the time. Can a judge halt assessments on a preliminary basis? It happens. The availability of equitable specific performance relief that's available in a district court is really limited only by the creativity of the counsel requesting it, as well as the district court's own sense of modesty and reserve. And of course, the latter, in some instances, can be a limited resource in certain courtrooms. So I think what I would conclude with is the thought that equity, I think, now is somewhat under-requested, equitable remedies. It's somewhat underused, both equitable remedies as well as defenses and other doctrines. And it certainly is, as it applies in our modern system of statutory review, under-theorized. But if you go through the pre-APA case law, if you go look at all those great old cases, you can find solid support for all kinds of interesting and useful strategies to obtain relief against the government. And I think it's something that those doing litigation with the government would behoove themselves well to study. Thank you.
Okay, let me add my thanks to Adam and Leah for all their work in setting up this conference, and also the fellow panelists, and also the earlier working paper workshop, which was very interesting, and I certainly found to be very educational. Here's what I plan to do. My comments can be wrapped up in a title, something like Regulatory Sequence, Mode, and Optimal Judicial Scrutiny of Agency Action. What I'm going to do is comment on the two papers, Kristen Hickman's and Nick Perillo's, and then offer some of my own comments about perhaps additional variables to think about in monitoring agency action and the court's role. And then, as Eileen suggested, I was going to do, close by talking a little bit about some deregulatory actions by the Trump administration, all in 10 minutes. So or maybe, 12. Or 12, whatever. So, first, I really do commend to you the two papers, the two principal papers of this panel. Sometimes legal academics write papers that are completely impenetrable or only interesting as a matter of theory. These papers really are of interest to professors, to judges, to private sector lawyers, and to agency officials and their lawyers. There's a very practical component, but they really illuminate things. So they're both terrific. Kristen's paper, as you heard a little bit, has wonderful doctrinal parsing of the law on finality, and also one of the nicer illuminations of how inter-circuit percolation and fleshing out of law is a function of our circuit system, where Supreme Court sets broad mandates, and then the circuits kind of work out different ways of thinking about it. And I view that as a good thing. I couldn't tell if she views this as a problem. I view it as, like many things, a valuable conversation with room for difference. At the end of her paper with Mark, there's a kind of a normative voice comes out that I always look for to see like where they come out. And so there's talking about risks of abusive agencies, dire circumstances, to the regulatory target if they disregard what an agency does. And it talks about frustration of the goals of the APA, and talks a lot about the importance of public participation, transparency, and accountability, certainly goals everyone would agree with. At the end, there's a reference that those who are targeted by agencies or are the recipient of an agency action can be worried about potentially ruinous civil and criminal liability. Okay, and so I think the general perspective is concerns with agency action that will lead to liabilities concerns. My sense is the paper and maybe the jurisprudence should do a little more, which kind of ties into her focus on pragmatic approaches, but a little more. I think that there should be more attention to the mode of the agency action. Is the agency action something that's more adjudicatory in nature, or is it more rule-like? And right now the paper doesn't really step back and say where this fits in the spectrum. Very importantly, what does the agency claim about the impact of its action? Does it claim that its action mandates immediate compliance and changes things, or is it something that the agency views as preliminary, or that maybe illuminates the agency's view to later on be defended? I think it's Bill Funk and a few others have said that is the critical variable, especially when thinking about guidance documents. I think there's a lot to be said about that. Next, I think that there's importance of thinking about the sequence of agency action. Where does the challenge action fit within a sequence of agency actions? As all of you know, especially sophisticated regulatory practitioners, most regulatory actions are embedded within a string of actions. That is, there are many actions that are potentially final, and then the question really is, how do you think about this? But another variable that I think is part of her pragmatic analysis, and especially comments today, is I think there's this importance of not engaging in a selection bias problem. Any case where someone is unhappy with an agency is a case where they think an agency has done wrong. But of course, if a court says the agency's mode of action is improper and requires something more, an agency will respond systemically to it. And so you need to think about the mode of action. If you require more process or you make it judicially reviewable, you need to think about what will happen if that's true right across the board, and that may end up disincentivizing agencies from being responsive, from talking to giving guidance, and that can be a loss for all. Or to put it differently, if you talk to practitioners, they're always begging for guidance documents, right? That everyone wants to know what the law is, but there will be some that people don't like. But for people to say a guidance document isn't a problem is not to say they are not valuable. At least when I was advising industry and municipalities, not-for-profits and the like, it was the search for answers and guidance that people wanted most. And so you don't want to chill that. And then I guess tied into this, I think you need to think about the fact, and courts need to think about the fact that agencies often do not know, in the sense that agencies are in the process of figuring things out through the sequence of processes, sequence of procedures, and whatever is set out to be final or needs to be done, you should have to think about the agency and how a sequence of actions and making them judicially reviewable may chill agency learning over time. So, Nick's paper is really interesting, as he said. It's really at the other end of the spectrum, not just in time, but if Kristen's papers focus on the idea of agencies maybe doing too much and causing too much harm, Nick's paper is talking about agencies that just won't do anything, and then the courts are trying to force the agency to act. I think that one interesting element of this paper is there is this big literature that I think we often hear about at the regulatory think tanks around town, agencies as turf builders, as rapacious growers of their power. But there is a lot to be said about agencies that have the problem of not acting, where inertia seems to be the most powerful force. I think many people who work with agencies, that's the problem they encounter. I'm sure we all could tell good war stories of trying to shake an agency just to do something, to give guidance, to give an answer, to issue a rule, to issue a guidance, or to issue an permit. And so his paper is very good. And I guess one thing about it is he talks about there's some variety, and correctly, in how courts handle all this. I actually think, I look at the paper and I kind of find myself reassured. It shows the fact that courts and litigants and agencies are in a sort of sequential iterative process, working things out, flagging what are problems, revealing over time what might be irregularities, and then more or less muddling through, like Lindblom said long ago, explains most bureaucratic behavior is muddling through, but kind of trying to figure it out where everyone is, I think, pretty respectful of what little they know, and also just the problems of strategic behavior always being an underlying concern. So I think it's a terrific paper, and again, as I said, valuable for all. So a couple bottom lines. So one is, I just think both papers would benefit to think about regulation always as not a thing or a point in time, but a sequence and a process, and that you need to think more always about sequence and process and identify where an action fits in that sequence and process. I think you need to think about the nature or the mode of the action, as I said, and especially what does the agency say about the impact of its action. I believe that should always be given very heavy weight. On the other hand, as I think Kristen's paper points out, if an agency action does suddenly change the stakes, that is, the agency's action suddenly puts someone not just in a difficult position, but may effectively heighten liabilities, I think that's totally different, and that's an area where the court should stand ready to review what the agency does. Okay, my last few minutes. As Dick Pierce alluded to, the Trump administration is finding that the process of changing regulations and regulatory strategies is time-consuming and difficult. And so some of the earliest and most interesting opinions that have come out have dealt with early efforts by the Trump administration to circumvent the regular process that this center and others, Hoover and Mercatus and the rest, have over the years said should be diligently policed by all. And so I've been waiting to hear complaints from all the regulatory and anti-regulatory think tanks about breaches of regulatory process. And I haven't seen much about it, but I do hope people will look at this. If you look at any regulatory rule, you should think about it being wielded in the hands of the person you don't like, and then say, am I comfortable with it or not? And I think maybe even in the world of academia and regulatory think tanks, it becomes tribal warfare. But I think people need to look at these actions. So where the most interesting action has been these efforts to evade finalized regulations and in some way nullify them, but without going fully through the rulemaking process. So far, the Trump administration, in reported opinions, has been 0 for 3 when they have sought to say, we're effectively not, we're going to postpone, delay, or stay. They've used different language, rules that have been finalized while we decide what to do with them. And the courts have said, no, that you can't do. Oops, there we go. So that means I'm down, that's 10, so I have my 2 minutes. It's perfect. Okay. And so 0 for 3, and the courts have said, no, if you have a finalized regulation under the Accardi Doctrine and the basic idea of what you can do with a notice and comment rule, it takes a rule to undo a rule. And you cannot, in a preliminary method, suddenly render the rule a nullity while you claim you might in the future change it. So there have been 3 decisions saying that, and as mentioned on the earlier panel, a lot of this grows out of both the FCC versus Fox, and especially, I think, much more importantly, the Encino Motor Cars case, which has clear majority opinions and also emphasizes, and a little more in the way it quotes the earlier cases, the importance of agencies engaging with facts and their own prior reasoning. Agencies cannot cherry pick parts of what they did, they need to engage fully. And so now the second wave of Trump actions, I think, having been boxed about the years by these first 3 cases, is proposals, notice and comment, proposals, but which do the same thing. And they say, we're proposing to render the rule a nullity while we consider whether to act in the future. And then they try to limit the notice, they try to limit the comment by saying, we don't want comment on something. And this, too, is under the law. There's less law on this, but this, too, appears to be illegal. There are a few cases, one coming out of North Carolina involving Department of Labor under the Obama administration, very early years, where the agency sought to change policy, revert to the old policy, and limit comment. And the court said, no, okay? And especially good, there's a concurring opinion by Judge Wilkinson that kind of says why this is a problem. And so, and the other element that I'll just close by saying is that I find really curious, just as a matter of a strategic choice, is in these several actions, especially you see these coming out of EPA, not only are these kind of halfway promises to maybe regulate, but the agency is not even trying to engage with the underlying facts, data, prior reasoning. In several of these instances, it doesn't mention 3 Supreme Court cases that constrain what the agency can do. In both settings, they don't mention large empirical data sets and reports that look at what's happening in science and out among the states. And whether they could change policy, that remains to be seen, but the case law clearly says the agency needs to engage with what it did before and underlying facts and data that drove the decision. And so I think what we're going to see is when these actions become final, they will have been tainted from the very start by the fact they have not been doing what the cases require, and what the cases require is in language from radicals like Justice Scalia and Justice Kennedy. That was a joke, radicals in the sense, but the
recognized it.
okay, so
time's up.
everyone's sound asleep. But in any event, but in any event, I hope we'll have more opportunities to discuss this. But again, the 2 papers are terrific, and again, thanks to the organizers.
Thank you all. Those were excellent presentations. Let's begin with a little inter-panelist discussion here. Who wants to go first? I saw much scribbling going on during the presentations. You want to go first?
Sure. If I could offer a comment on Nick's paper, which I enjoyed very much and I thought really is a novel take on an unexplored area of law. I mean, everybody follows the cases where the government loses on the merits, but nobody thinks, well, what happens after that, which of course is, for the actual parties, the actual litigants, is as important, if not more so. So much of it happens not merely in the shadow of the threat of contempt, but in the shadow of any type of urgency or even recognition. There often is a huge disconnect between in many times, Department of Justice lawyers, or it might be general counsel's lawyers for agencies with independent litigating authority, between them and the actual people in the agency who do the work. So if there's a requirement, for example, that an agency undertake a rulemaking, or that it modify a rule in a particular way, or that it do basically anything, the lawyers can make lots of representations, and frequently they want to. They're eager to be in good graces with the court and to make accurate representations to the court. But at the end of the day, they may not have a very detailed understanding of what it is the agency can do, what it is that it is doing. And I've seen this in my own practice where in many instances, Department of Justice attorneys representing agencies have really just had no idea what's actually going on in the agencies. Where are they on a particular schedule? What actions have been undertaken? It's very hazy and murky. They might have a very high-level view of things through a declaration or something of that sort. But the moment a judge tries to drill down into it, all of a sudden you're in the murk, and the counsel at best can offer to get back to the court. And that can be a real hindrance and something that, at the very least, runs the clock, and at the very worst, can almost seem like a type of recalcitrance.
Thanks very much for that comment. I mean, I think it's very important to a full understanding of this phenomenon to somehow get at the internal dynamics of the government itself. And the point you make about the opacity of the agency, even to its own counsel, is a very important one. I mean, obviously from a research perspective, in terms of making this part of the ongoing scholarly project, it presents something of a source problem or a research problem. Although, I mean, one can interview former government lawyers and officials who have some distance on the subject and, ask them to speak generally in ways that wouldn't breach their obligations, and that could potentially be one way of getting at it. If anyone has other ideas for how to get at these dynamics, maybe in archival records of actions long ago or something like that, I appreciate hearing them.
One thing I'd say that, as far as Nick's paper, we were talking last night at a pre-conference dinner. It was unbelievable. But that there was very interesting DC Circuit argument on November 9th that is worth looking at for people who follow this. It was EPA defending a seeming violation, or they were only 17 years behind the date they were supposed to have issued a regulation, and then there was further backpedaling by the current administration from what had been finalized late in the Obama administration. But what was interesting there about the discussion is the Department of Justice lawyer was trying to defend an action where it wasn't really clear why some things had been done. And finally, the DC Circuit, the judges said, well, you said someone was here from EPA. Could he maybe get up and explain to us what is going on and why this has happened? You know, who made this judgment and why? And so you hear this long pause, and he stands up there, and he wasn't expecting to argue, but he did finally say something like, well, this action went up the chain of command and was ultimately the administrators. And that was it. And then the judge said, well, doesn't the agency have to make these findings and this finding? Judge Santel, don't they? Isn't this the standard and they have to comply with it? And the Department of Justice lawyer and EPA just they were a bit flummoxed by this. But it was an unusual example where the judges, during the oral argument, were no longer willing to hear the lawyer. They wanted to hear the top person who knew what had been going on at EPA, and that person tried to, but may not have reassured them. But it was, and I was looking for it, it was Sierra Club versus EPA, and it was a November 9th DC Circuit argument.
Professor Hickman, I noticed you making a lot of notes. Is there something you'd like to, Nick, go first.
I very much appreciate that suggestion, and certainly I'll look at the oral argument. I do have a question for Kristen Hickman about finality. So in the literature on guidance and the sometime abuse of guidance, some people make the argument that the most acute problem is the phenomenon of guidance that's inconsistent with the Enabling Act, or that goes beyond the Enabling Act. And you know, you're balancing the potential for abuse of guidance and therefore the need for some judicial review of it against the fear, as you said, that you know, more scrutiny of guidance is going to chill the agency from issuing it, when maybe the vast majority of the regulated industry just wants to know what the agency is thinking and wants more communication from the agency. But I mean, in some of the guidance literature, people have made the argument that evaluating whether the guidance violates the Enabling Act is relatively low cost compared with determinations about whether it has an adequate factual basis or whether it was arbitrary or capricious or something along those lines. And so the argument is sometimes made that from a functional perspective, you could solve the most acute problems with the abuse of guidance at relatively low cost if you just let people into court whose claims are inconsistency with the Enabling Act. Now, obviously, that's awkward from a legal perspective. Is final going to mean one thing with respect to one claim of unlawfulness and a different thing with respect to a different claim? Maybe you'd have to amend the act in order to get that result. But I just wonder what you think about that, both as a legal argument and just from a functional perspective of how we should treat guidance.
Yeah, so thanks for that. You know, and I think this is one of the things that I've been thinking about in terms of pulling apart different doctrinal strands and different kinds of challenges. Because oftentimes when you talk about guidance, the challenge that gets put forth is that it's really a legislative rule and it should have gone through notice and comment rulemaking. And I can appreciate why courts, in their quest not to chill guidance, would say we don't want to turn every single guidance document into a legislative rule that should have gone through procedure, you know, public participation. On the flip side of that, though, you know, it does strike me that, you know, it isn't quite so hard to evaluate substantively, presumably under Skidmore, you know, whether something is inconsistent with the statute. as a substantive matter of interpretation, or for that matter, and this is one of the ones that has been bugging me a little bit, is when agencies are changing their minds. You know, we're seeing a lot more instances of using guidance where initially we had a guidance document that said X, and now we have a guidance document that says, no, the statute really means Y. And that inconsistency is a real problem. And, you know, again, I'm not suggesting we need to go through notice and comment rulemaking, but at least some sort of explanation as to why we need to change our mind. You know, I think fortunately, hard look review is very fluid. And I don't think you need to necessarily, you know, it's such a malleable doctrine that I'm not sure you would need to employ it in all of its full glory in terms of have you considered all the scientific studies and everything like that in changing your mind, so much as have you offered a reason why you changed your mind. You know, so, you know, some of this ends up being a question of which sorts of challenges a court is willing to entertain against which kinds of modes of agency action, to get to Bill's point. You know, and so, you know, I'm not sure that you necessarily need to amend any statutes to get there, so much as just recognize the doctrinal tools that are available. And, you know, just because something isn't a legislative rule doesn't necessarily mean that it shouldn't be susceptible to some amount of judicial review. I'm not sure if that completely addresses your question, but that's kind of the direction my thinking is going anyway. Now, how you boil that down, I don't think you can ever boil that down into some sort of bright line test, which is one of the things that makes this paper a little dissatisfying. You know, it's always nice to be able to boil things down into bright line tests, but sometimes you just can't. But that's kind of the direction I'm going anyway.
We just have a few minutes left, and I'd like to provide the audience the opportunity to engage with the panelists. We have microphones on either side of the room. We have one question right down here, and the next one will go to this gentleman here.
David Wagner with CC Strategies. For Mr. Grossman. Mr. Grossman, you spoke very interestingly of...
Hold the microphone closer to your mouth, please.
Mr. Grossman, you spoke very interestingly of injunction-specific performance directed at agencies. How is that similar or different to mandamus? And if Marbury had been argued in the context of specific performance in the shadow of the Constitution-specific bestowal of equitable powers on the federal courts, might our entire world look very different?
Yeah, I suppose. You know, particularly, I mean, when you're talking about these types of remedies, you know, age-old, you know, mandamus jurisprudence, as well as, you know, jurisprudence under, you know, the old writ system, really does have a currency and relevance. And some of it does carry through, you know, both, you know, in our normal types of regulatory review cases and normal types of agency challenges, as well as some of it carries through in the sense that it's never been disavowed and it's not off the table. But at the same time, it's just not, these aren't the kinds of remedies and the kinds of doctrines that people think a lot about. So I think thinking about mandamus and looking at, you know, those types of cases from long in the past before we had, you know, the generic APA cause of action and the like, is a really useful and valuable thing to do. And it's something that I think can really benefit from a lot more attention.
This gentleman?
Hi, Peter Tolsdorf with the American Petroleum Institute. Professor Busby, you noted the administration going 0 for 3 on their rule postponements under Section 705. As you may know, a couple weeks ago, EPA in the waters of the United States rulemaking proposed to add an implementation date to the waters of the US, 2015 waters of the US rule, effectively a 2-year delay from when that implementation date is finalized. They didn't amend the effective date in the Federal Register notice. The agency said, we're not amending the effective date, we're providing for an implementation date. I'm interested to get your thoughts and the thoughts perhaps of the panel on that approach to postponement of the rule.
I haven't looked at that exact language, so I'm not sure, but I think that the test the courts seem to be using, and this is why the mode matters, is, if the agency is effectively telling the world the rule is of no effect for a chunk of time, whatever the word that's affixed to it is, if they are effectively undoing a regulation, and especially when you think about the standard making inaction so virtually unreviewable. If an agency kind of says it's not in effect because we think we'll do something 2 years in the future, that obviously can stretch into many, many years, and then you can have the effect of undoing a regulation with no rational explanation, reasoned decision-making, or compliance with Encino Motor Cars and Fox. And so at least the cases so far, that's what they're concerned with. They're saying you can't do it that way. So, but I haven't looked at the particular language of this this recent notice. So does that respond?
It does. That's exactly the situation here. They're saying we're undertaking a new rulemaking to revise the rule. We're going to need about 2 years to do so. So we're introducing a new implementation date of the 2015 Waters of the United States rule. So it's a different tack. And I mean, there are very few cases about this agency efforts to limit notice, and in so doing. But this case, I believe it's this North Carolina case I mentioned with labor. That had the very persuasive Wilkinson concurring opinion. They talked about, like in that case, the agency said we're just going to return to the old, as though that would make it somehow subject to some lesser scrutiny. And the court said, no, that is still a change in policy and needs to be justified either way. So I don't think a kind of, with the waters of the Clean Water Rule and the recent thoughts, I think the agency thought by saying we're just returning to the law as it was, that would mean it would deserve lesser scrutiny. That might make it easier to justify in the end, but I don't think that changes the framework that the court should apply.
Having reached the end of our time and seeing no hands up, I have a final thought before we close. 40 years and 3 months ago, the United States National Aeronautics and Space Administration launched Voyager 1 on a mission to explore the outer planets in our solar system. It's NASA's farthest and fastest spacecraft and the only man-made object in interstellar space. It is now more than 13 billion miles from our sun. It's measured from our sun because its distance from the Earth depends on what time of year it is and where the Earth is in its orbit around the sun. NASA scientists activate thrusters on the spacecraft to reorient it so that its cameras and antenna are pointed in the right direction. Recently, it became apparent that these thrusters, after more than 40 years of traveling through space at an average of 40,000 miles per hour, the thrusters were finally losing power and therefore their ability to reorient the spacecraft. After spending a few months studying the problem and pondering solutions, NASA scientists tried something else. The spacecraft has another set of thrusters it used earlier in its mission, but they've been dormant for 37 years. There are people in this room who weren't born yet. More than 13 billion miles away, more than 37 years dormant, the thrusters responded to NASA's commands and reoriented Voyager 1 so that its cameras and antenna, once again, are pointed in the right directions. This happened just last week. It makes me so proud of American scientific ingenuity and competence, and so hopeful that America's legal community can also solve whatever problems face it. Please join me in thanking our panelists.